Namaskar viewers, hello and welcome to Sansad TV. I am Tina Jha, you're watching Perspective. Ease of justice is equally important as ease of living, an assertion made by Prime Minister Narendra Modi while addressing the first All India District Legal Services Authorities meet on Saturday. Addressing the event, which was also attended by Chief Justice N.V. Ramana and Law Minister Kiren Rijiju, the Prime Minister said people of the country have immense faith in the judiciary and that access to the judicial system is equally important as the delivery of justice for any society. Reiterating that this is the time of Azadi ka Amrit Kaal, the Prime Minister said it is a period of duty and that we have to work on the areas that have remained neglected so far. He raised the issue of sensitivity towards under-trial prisoners who, as per the last prison statistics, comprise about 76% of the total prison inmates in the country. So what is being done, in fact, or should be done to expedite the release of under-trials? How can we strengthen our judicial system to ensure that justice delivery is not just timely but also effective? This and related aspects in perspective today with distinguished members on the panel joining me on the program. So let me begin by introducing them to you. Absolute pleasure to welcome with me in the studio Mr. Suresh Chandra, former Law Secretary, Government of India. Thank you, sir, for your time and welcome to Sansad TV. To my left is Dr. Rajiv Nanda, Senior Advocate, Supreme Court of India. Welcome to Sansad TV, Dr. Nanda. And joining us virtually is Dr. Justice Satish Chandra, former Judge, Allahabad High Court. Justice Chandra, pleasure to have you back on my program. Good evening. Hope you're doing well. In fact, allow me to begin the program today with you. So several significant assertions made by Prime Minister Narendra Modi indicating the urgent need of judicial reforms in the country. How do you interpret the Prime Minister's assertion, sir?
Look, in India, there is a lot of pendency. More than 4.25 crore is the pendency. And here the number of judges are also very less. Per million, you will surprise only 19.66 judges are there per million. And people are waiting since long, and especially in criminal cases. For example, these cases, 80% cases are pending in the lower court, and in high court, 60 lakh cases are pending. Even in Allahabad High Court, more than 10 lakh cases are pending. So this is the main issue. So what district legal service authorities are giving and what Prime Minister said today, that is to provide the legal service or legal help to the person who can't afford, who cannot pay the fee to the advocate and due to illiteracy and poverty. So this was the idea that to provide the free legal service to that person. Sometimes he is just innocent, his punishment is hardly a few months, few days, but he is waiting for the justice and he is in the jail without any trial for a longer period. So this is the injustice to the accused person. And Article 39A of the Constitution is providing the equal justice and free legal aid. And this is clubbed by Article 21 of the Constitution in the case of the Kishore versus State of Himachal Pradesh, 1991. Supreme Court said, Honorable Supreme Court said that this is the part of the Article 21 because this relates to the liberty and life of the accused persons. And 304 CRPC has the similar provisions. So they will have to provide it and at the district level under the supervision of the district judge, who is the chairperson, ex-officio chairpersons of the district legal aid committee. And it is the duty of the district judge to provide the legal service, legal aid when it is demanded by any accused persons or who is not demanding even then and there is no representation on his behalf. Then this is the duty of the district judge to provide the legal service as laid down by the Supreme Court in the case of B.B. Chauhan versus UPSRTC in 1990, where a person died in the road accident. So this was the whole positions, this one.
Okay. Dr. Nanda, coming for your perspective, you know what the Prime Minister said today about how ease of justice is as important as ease of living. So when we look at the ease of living parameters and how our different cities have performed, we see a remarkable improvement over the years. But if we look at the ease of justice aspect, it can't be said about different courts of our country. Looking at the huge pendency of cases, over 4 crore cases are pending in different courts across the country. So to that aspect, help us and our viewers understand what are the factors which are behind this clogged state of Indian judiciary?
This is really hitting the nail and the right question in the current scenario to be answered. Today we are faced with crores of cases at the district level lakhs of cases at the High Court level and, of course, a good sizable number of cases at the Supreme Court level. There are many reasons for the accumulation of such big chunk of cases. One being the lack of infrastructure, which includes the lack of judges. As the previous speaker has spoken, that one judge per lakh. So lack of infrastructure is one reason, if not the only one. There are other reasons on which the Prime Minister has spoken today. And this was, I will say, a very welcome step. People are looking forward from the country's Prime Minister to address the issue of justice delivery to the common man, to the last man in the street. I will put it in the way that justice is required in the life of a person and is necessary to such level as salt is necessary in the vegetable. So the delivery of justice should be in such a atmosphere and such way that it reaches the last man in the street. Now, as I said, there are reasons for the delay in justice delivery, where this today's district level people who were collected in the Vigyan Bhavan and which were addressed by the Prime Minister, they were addressing issues. The Prime Minister addressed the chairman and the secretaries of the district level legal services committee to sensitize them and to encourage them. We will have to really look into for not only infrastructure development, but the manner in which judges are to be appointed, the strength of the judges has to be increased, which is the job of the executive to be looked into, and of course the manner, as I said, of the justice delivery system.
Okay, let me get in Mr. Chandra here first. So two important aspects, Mr. Chandra, emerging is the huge, vacancies, judicial vacancies, and the fact that, there is abysmal judicial infrastructure that needs to be improvised. So towards both these aspects, what are the kind of steps that we have undertaken and we further need to enhance them in the times to come?
Yes, madam, before I highlight these two things, that is the adequacy of the judges and availability of infrastructure for the clients as well as for the courts or the judicial officers. I would like to highlight the factors which are there. Number one, number of cases are increasing not only because of the infrastructure non-availability or because of the non-availability of the judges. Cases are increasing also because of the awareness amongst the people of their rights. Second thing, more is being highlighted about the inadequacy of the judges. Keeping in view of the social conditions, economic conditions, and the political condition of our country, I would say that it is not the only factor, inadequacy and this. To some extent, there is a need of the competency level. Earlier also, I used to highlight that issue. There is a need of enhancing the competency of the court cases management as well as disposal of the cases. Other aspects, definitely infrastructure has been, improved a lot in last 20 years. I remember for the first time, 3,500 crores rupees were given in 2000. That was the first kind of, grant which was given by the center to various states. Now, in achieving the goals of access to justice, there are factors. One of the factors, apart from the infrastructure as well as the judges are concerned, are the factors that adoption of technology. And this time, the Honorable Prime Minister has highlighted not only highlighted, but he has used this platform addressing directly to the district legal service authorities. This is for the first time that the Prime Minister has addressed the district legal service authority from the Vigyan Bhavan. That is a welcome step, and this is also important because most of the people at the district level, they are complacent as far as the woes of the people are concerned, under trials and all. So this will not only sensitize the people, this will also sensitize those who are in helm of the affairs, those who are the district judges, those who are in the committee, that way. So I am of the view that if you can, I mean, if such kind of conferences are convened and the people are sensitized, we can, I mean, have very good results in future.
Okay. Justice Chandra, a very significant point spoken about how there is need to leverage technology. And in this age, we can't say that technology is something that we want or not. It's become a necessity. And the COVID pandemic has proved that. How are we in the judiciary leveraging technology and, in courts across the country, not just limited to certain states, but, percolating to the states down in the ranks as well, to reduce this pendency of cases, to reduce the backlog of cases, which is the prime factor today behind the clogged state of Indian judiciary?
Not from the today, but it was earlier also. When we were the students, pendency issue was there and there were so many seminars.
And it's only been increasing, sir.
Yeah, it is increasing day by day. No doubt that infrastructure and number of judges have also increased, but pendency is increasing every time. Even in Supreme Court, you have seen, this is the 76,000 cases are pending there. In High Courts also this is there. And it has so many aspects. For example, the first of all is the appointment of the judges. It takes a lot of time. So there must be a procedure to start the process well in advance. You know very well who is retiring when. This is already fixed. I remember one case in Madras High Court. The Chief Justice refused to recommend the 2 more cases because 2 judges are likely to be retired in the next 3 months. So he said, sorry, unless they will not retire, I will not recommend 2 vacancies. So that is not the way. Like the UPSC, for example, civil servants, they know how many vacancies will arise in the next year. Or so they start the process for that one without waiting this thing. So systematic procedure is required for this one on regular basis. And second aspect, one thing I will say, the new idea is this, that magistrate at district level this time, the Prime Minister, Honorable Prime Minister has spoken about to the district authorities and district judiciary. He is discharging the same thing what Supreme Court judge is discharging.
Okay,
he is also dispensing the justice.
Mr. Chandra, that's an important point that I'll take across to you on, the appointment of judges. A very important aspect that he has highlighted is, we know well in advance which judge is retiring when. Why don't we start the procedure earlier on to, to expedite the procedure?
See, there are certain technical aspects into this. There are a lot of consultations. First proposal comes from the high courts. Thereafter, when it comes, then it goes to the governor, the chief justices, then the reports, inputs are, intelligence reports are collected. Thereafter, it is put up to the Chief Justice of India's collegium. Thereafter, so these stages at times, what happens, sometimes the Chief Justice retires, sometimes the government changes, and there is a thinking, maybe once the Chief Justice has retired, let us have his views also. Sometimes there are certain, certain gray areas in their recommendations, so they want to have a second. So these are all procedural aspects. I think I am of the view, I definitely support Justice Satish Chandraji on this point. But sir, it is not the only factor that is the appointment of judges. I will say, had there been an All India Judicial Services wherein, now you see, this is 66% of the judges are appointed directly to the High Court judges, and 33%, 1/3 are promoted through the lower judiciary. Another aspect can be, I was of the view in 2000, in the year 2000, when I recommended to the then Law Minister, Mr. Arun Jaitley, that if you can convert it 33% direct recruit and 66 and 2% from lower judiciary, you will see the quality, but somehow there are certain pushes and pulls. The things are not moving.
Okay.
Other alternative, madam, before I conclude, other alternative is, as there is also a mandate of the under the directive principles of state policy, that there should be an all India judicial services. Had there been an all India judicial services, the appointment delays aspect can be taken care of.
Okay, Dr. Nanda, let me ask you a question related to the All India Judicial Service that's being talked about, and also another aspect which has been proposed by the Chief Justice of India, N.V. Ramana, on several occasions about the need to have a National Judicial Infrastructure Authority. So one that has been proposed by the government, the other that is being pitched by the CJI. How are these two procedures or frameworks, if you look at it that way, are going to bring about reforms and the changes that we are talking about?
Yes, certainly. All India Judicial Services like the IPS and the IAS, if it is an IJS, it would certainly make a big impact in reducing the pendency. But I have a suggestion here. Till the time we get that, which is a very distant thing to achieve, certainly not impossible, but a distant dream to achieve. Till that time, we certainly can have ad hoc judges, because and the virtual mode of hearings. This will certainly have a big impact on reducing the pendency of the cases, which are mostly, as I said, in crores at the district level. At the district level, in case we can have, instead of waiting till the time, which is a really laudable effort, in case we can achieve the national or the national level judicial services, till that time we can have the ad hoc judges, because that will, if we have those and the ad hoc judges holding the e-courts through the virtual mode, as the Prime Minister suggested, by the virtual mode, we have seen it very successfully during the pandemic. And I will suggest and recommend to the Government of India to look into what the Prime Minister has said very sensitively, because Prime Minister has indicated really a very good suggestion that we should encourage in this Amrit Kaal, when we are celebrating the 75th year of independence, the Aam Aadmi in this country, the last man in the street, should know that justice is available to him. And the manner in which I just said, one of the reasons is lack of the judges, and we can solve temporarily by the ad hoc judges appointment.
Absolutely. Justice Chandra, when we talk about parliament disruptions, the question arises about how the common man's faith is eroding in these institutions, that the credibility of the institution is at stake. The same goes for the judiciary as well. So when the common man loses that trust, that we approach the court hoping for justice, but justice is being delayed, and justice delayed is justice denied. So when we talk from that aspect, how do we ensure that this credibility of the institution is not eroded? The common man has that kind of respect for law, has the same kind of faith in the judicial system.
Still, common man has a faith in the judiciary. He usually says, I will see you in the court if there is some dispute. And coming back to the pendency issue, I agree with Mr. Suresh Chandra that all India judicial service is required. And a bill was introduced which was set aside, or you can say the Supreme Court has set aside that propositions, and judicial service was not created. Again, there is a need to bring it with the improved ideas or something what Supreme Court said, so that can be removed. So that is one aspect. Secondly, about the judges' appointment ad hoc or so, that will take the same time and same procedure. So my suggestion is this: the procedure should be started 1 year in advance. For example, for the 2023, they can start the procedure right now. How many vacancies will be created in the high courts, various high courts, and they can start it. And as I was suggesting last time, this in government of India, you will see the secretary and PN will retire at the same age. So why not the magistrate and the Supreme Court just retire at the same age when they are dispensing the justice at different level? So the age should be uniform. So about 65 years of even the magistrate of 65 years, he should go. So this will reduce the pendency, and there will be no need for the ad hoc judges when this aspect will come on. Mm-hmm. And other aspects for the reducing the pendency, you can see still for the writ petition, the stamp fee is 100 rupees, which was laid down sometimes in the year of 1900 something, 1907. under the Stamps Act. So that can be increased also. And you see, other aspects, as you rightly mentioned in Parliament, there is disruptions. So here in the court work also, some advocates go on strike, they contest the elections, they expend the lavish money. So this aspect should be checked, and these are contributing for the pendency. And
I think whatever these factors that we are talking about, I think the end result is that the common man, Mr. Chandra, has to wait for prolonged years, not just months, but years together for justice to be delivered. And that is something that we need to fix. We are celebrating a landmark, year this year, or the 75th year of independence. What's important is that this is the Amrit Kaal. We need to fix the wrongs that have been done. We need to now turn our attention to those that have been neglected. And towards this, the Prime Minister spoke about the need to expedite the release of the under trials. They comprise 76% of the total prison inmates in our country. They've been languishing in jails for petty crimes, but for years together for, lack of justice. How can we ensure that this procedure at least is expedited?
I will take you to, again, NDA 1 Kaal, when we brought out number of judicial reforms, including one of the law, that is the CPC amendment of 2002. And that was the bill or the law which was discussed at a very higher level with the Attorney General of India, by the Law Minister himself, and I was also party to that. That was one of the a very fine, law which came out, and we tried to minimize the total cycle of a civil case to 1 year, which used to be 10 years earlier. And this was debated, and it was constitutionally, it was upheld when it was challenged. But what happened later on? The timelines later on were diluted or have been diluted by the judges themselves. And yes, I do agree that there is an independence of judiciary. But independence of judiciary perhaps has been stressed to the extent not complying with the law made by the competent legislature. So to some extent, if the law is followed in true spirit, like we came out with the CPC amendment, we came out with the 138 Negotiable Instrument Act and all those. If with due respect, this is followed in true spirit, and the judgments are pronounced within the time limit, that is 30 days, the lot of pendency can be brought down. And second aspect I will highlight. We are nowadays conducting virtual hearing through video conferencing in the Central Information Commission. And our, filing is nowadays less, but disposal is more. Though there are vacancies, 4 vacancies in the commission, but still our disposal is more. So if you can adopt the latest technology and can bring the management system in court case management, then definitely you can bring down. And of course, the supervision by the high courts and by the Supreme Courts through their own internal mechanism, so that every judge can be put to task, and they can be, responsibility can be fixed as far as the quality and the quantity both. We can bring down.
So what we are seeing, Dr. Nanda, is the fact that, what the government proposes, the Supreme Court or the judiciary disposes, and the vice versa. If we want the betterment of people, and if we are talking about the way forward where the common man should not be at the receiving end, do you think there is need for more coordination among these institutions, which even though are working independently, but at the end are accountable to the public of this country?
It's very difficult task to make the three. It's a utopia actually to expect all the three in the present day scenario to be working in the same line, because with all respects to the courts, what they are doing is what was not contemplated initially. What the executive is doing is something exceeding their jurisdiction. So I will, with respect, say that we should concentrate for reducing the pendency within the given framework itself, it is not that we don't have the means to do it. We still have, like we just discussed, there are many things available to us which can expedite the justice delivery system by, let us say, the e-courts, the continuous e-courts, the continuous lok adalats, and we must do it to increase the scope of the lok adalats. Currently, the permanent lok adalat or the periodic lok adalats, as and when they are held, are having a limited scope and the limited jurisdiction of people coming to them voluntarily. It should, the scope and the jurisdiction of lok adalats should be increased. I'm just giving you examples within the system itself, within the available means, because to make the three wings coming on the same page for reducing it, it is really a utopia to think. Within the given means, we have the strength to do it. The only thing is there is a lack of will to do it.
That can happen through all of these aspects that we've discussed on the program today with the three guests who have joined us on the program. That's all the time that we have to discuss this very, very vast topic that emerges each time the government or the judiciary speaks about some kind of reforms that need to be brought about. But it's only hope that we have that this judicial system will improve and that the common man will not have to suffer anymore. That having been said, I'll have to wind up the discussion. I'll thank all my guests for joining me on the program today and sharing your thoughts with us and our viewers. Absolute pleasure to have you all three on this edition of Perspective. Thank you to you viewers as well for your time. I'll see you same time on Monday now with another brand new topic. Until then, take care of yourselves and keep watching Sansad TV.